It's our tax time here to talk a little bit about things that we're doing with powers of attorney and other things that have to be in place for us to represent people before the IRS, give information. I'm excited about this because people in tax resolution and tax representation, I've been doing it for almost 30 years, I think. Gosh, I got to think about about 30 years I've been doing tax representation. And it's a really complicated area. It's very rewarding to help people, especially when you help them solve their problems, you build their, and then they get back on a new path, you help them build their business. As a firm, I have two firms, and we're going to talk about both a little bit today. Private Tax Solutions is our accounting firm, and we do accounting, tax resolution, business consulting, pretty traditional accounting firm, except we have a deep niche, deep knowledge in tax resolution. So anytime somebody has a bunch of unfiled tax returns, a big tax balance owing federal or state, tax liens, any of that stuff, we're pretty good at that stuff. We do a lot of offers in compromise. We do a lot of installment agreements, partial pay installment agreements, lien withdrawals and releases. We just do a ton of representation work, and it's a way that we engage with clients to help them get out of trouble and then become great clients because we get them on a solid financial foothold and they move forward. It's amazing what happens to people when they get out of tax trouble. As I say, all of their life changes. They improve their financial position, their business grows, people get married, they just clear out all the clutter and all the challenges that they've had for all these years with the IRS bird dogging them, harassing them, making their lives a living mess, and just creating a difficult situation for them. And when we clear out all that clutter, it's amazing how much people will just grow and become very vibrant in their business and their personal life. So I'm going to talk primarily today about three forms that we use a lot, why they're important. Feel free to ask questions, and Malcolm, if you kind of keep me posted on questions that you see that I ought to address, go ahead and DM me here on YouTube or Facebook or Instagram, wherever you're logging in. Ask your questions because I wanted this to be interactive. I recognize that 2848s are very confusing. The forms aren't very, the instructions aren't very clear in some cases. I've seen these forms done wrong a lot because we take over audits and collection cases from other firms, and we see the old power of attorney or the 8821, the tax information authorization. I see mistakes left and right. And so I'm just going to tell you how we do it, guys, and why we do certain things the way we do, and hopefully it'll benefit you in your practice. First of all, before we ever do a tax representation project or gather information to determine whether we want to take a client on, I just want to let you know there's always a fee associated with that because it takes time to get these documents processed through the Central Authorization File Unit. We call it the CAF unit. It used to be back in about 2014, I think it was. We had electronic authorization, which meant you went into e-services, you filled out the power of attorney, you had the client sign it, you scanned it and saved it in your records, and then you click submit and you were live. You had instant access to transcripts and records. You could instantly talk to practitioner priority line. You could instantly talk to collections. You could talk to whoever you wanted within the IRS because you were live instantly. Well, in 2014, the IRS, under a guise, I'll just say, removed electronic authorization. And the reason they said they did was to save money, and they promised that they would process powers of attorney much faster. They promised a 3 to 5 day turnaround. They have never, ever, and I would invite the commissioner of the IRS on my lives or his staff who have claimed that they would do this. They've never been able to do that. In fact, before COVID-19 hit, I think in most cases we were running at least 3 weeks behind at the CAF unit, some cases 4. So we'd submit a power of attorney or an 8821, And 3 weeks later, we run in our office what we call CAF checks. That's where we use software to check to see if the CAF is cleared through e-services, the power of attorney is cleared, and we know immediately whether it's happened or not. And once we know it's cleared, then we start to download transcripts and documents and things we need. Well, during COVID, that is now upwards. I'll have to ask my staff that are running POAs and TIAs, but I think we're running a minimum of 8 weeks and maybe as many as 10 weeks. So go back to 2014. In 5 minutes, I could fill out the POA. The client could sign it, we scan it and submit it, and we were live, and we could call whoever we wanted in the IRS and download transcripts through e-services. Today, we're at a minimum of 8 weeks. So I know the IRS says that something's coming, but you got to remember they've been saying that for 7 years now. And the ruse that they created about why they were terminating electronic authorization didn't pan out. The reason they terminated it is somebody at the IRS didn't renew a software license, and that was going to cost them money, and they panicked. And so rather than, telling people what really happened, they said, well, we'll save money by just processing them manually, and we'll save time by doing that. Neither of which were true. There's no way that a software-based system can outperform, or there's no way that a human being can outperform a software-based system in processing these POAs. So it's really unfortunate that the IRS chose to eliminate electronic authorization. Obviously, I'm calling them out because we need to bring that back. If the IRS can trust us to do electronic filing for tax returns, we ought to at least be trusted to file a POA electronically. They can audit me anytime. They can come in, and we retain copies of our powers of attorney, our TIAs, the tax information authorization, the 7216 consents. We keep that all scanned in our files. And I think that would be a much more productive and efficient way to do this rather than creating the 8-10 week mess that we are now in. But nonetheless, that's where we are. So we have to recognize it. Now, we have a lot of workarounds for this, guys. So, for example, when we take a 2848, here's one right here. When we take a 2848 today, first of all, I don't even prep it. It's already prepped. Everything's pre-filled except my signature, my other tax professional signatures that are on the POA, and the client's information. So we take that generic pre-filled POA. One of my admin teams fills it out with the client. They get it signed by the client. We sign it. And then what we do is we actually fax it now to the CAF unit. We don't want any wasted time. So we fax it. And then if it's an urgent representation matter, then I'll actually call practitioner priority service, or I'll call collections, ACS, we would call that, or the revenue officer. So depending on where I need to go, lien unit, practitioner priority service, ACS, automated collections, or an RO. And immediately I'll just tell them, guys, the POA has not processed through CAF. Can I fax this to you? I'll fax it. There's some delay for maybe 10, 15 minutes while they're getting the POA in the fax inbox. They all use eFax, but I think they use the time to go get a cup of coffee, go to the bathroom, keep me on the line, and they do that to everybody. And then they come back on, they say, okay, I got the POA. It's all signed. How can I help you, Mr. Miller? And that's one way we'll kind of accelerate things a little bit. If we've got an urgent matter, we'll call the service, we'll fax in the POA, and then we'll immediately be able to talk to them. The advantage we have to once it's formally processed through the CAF unit is now we have live access to transcript data in e-services, and I can use that data to create reports, to provide important file information to my clients or their advisors. So if they're working with a bankruptcy attorney or some other attorney, I can give them data like what the collection statutory end date is, whether there's an opportunity for first-time penalty abatement, what the assessments are, what the penalties are, whether there's other opportunity for penalty relief. Once I have access to all this transcript data, it is fantastic because I can use that to advise my client. But when they're in a crisis, which happens a lot, people will ignore the collection cycle. they'll ignore the RO or the revenue agent, and then they're in a crisis. Now they need me immediately. Then I've got to go into action and do the workarounds. But the ideal situation is we've got a little time to process the POA and get it through CAF. Now, one of the things you want to make sure you do is you always want to lower the expectation of your client. So when I take a POA, I'm sure to tell them, look, this is going to take at least 8 to 10 weeks to process. So I won't be able to advise you on anything for 8 to 10 weeks unless it's a crisis. And if you have a crisis, let me know. If you get a certified letter from the IRS, or if the clock is ticking for something, I need to know right away because I've got to do my workarounds. If there isn't too much urgency, then we can fax it, wait the 8 to 10 weeks, and then get working on it using the transcript data that we're going to pull down. I always tell them, guys, it's going to take a long time. You've got to know that. We personally as a firm, because of all the work that's involved, and I might be high, I might be low, it's just a number, but we always charge $75 per power of attorney. And it's just because it takes time to process these. I've got to use staff to process them. And then they've got to bird dog this thing all the way through the process until the POA or the TIA clears CAF. Once it clears CAF, then that part of the engagement has ended, which is just getting the documents signed and processed. The next part of the engagement is the initial discovery, the transcript analysis, and providing a report to the client. And that's a separate fee. And that will allow me to know what the IRS, how the IRS sees the problem from their end. So I always tell the client, look, I can only know what you tell me. And so I see the problem through your eyes and what you think the problem is. I need to know what the IRS thinks the problem is. Then by knowing what you think the problem is and what the IRS thinks the problem is, I can then build solid advice for you and help you get out of the trouble you're in. But none of this really kicks into high gear until there's A, crisis, or B, everything processes through the CAF unit and we're now live and we have access to transcript data. So let me talk about the 3 documents we use a lot. And I'm going to start by talking about IRS Form 8821. That's a tax information authorization. This is a great document when you don't know if you want to represent your client and you only want to gather information. It allows you to access to transcript data. It allows you to call the IRS and request fax of transcript data or to get information from the IRS, like a collection statutory end date, we call a CSED date, or an ASED date, or some other end date, so an RSED date. It allows you to get just basic information from the IRS. Let me read from the instructions what it says you don't have the ability to do. And a lot of times people will use this 8821 when they're not a licensed tax professional, meaning they're not a CPA, enrolled agent, or an attorney. So only a CPA, enrolled agent, and attorney can represent somebody before the IRS, unless there are a few other unique caveats, like you're an employee of the company or something like that. But generally, only professionals who have a law license, a CPA license, or an enrolled agent certification can represent somebody before the IRS and advocate for them. It doesn't authorize you to speak on the client's behalf. It doesn't allow you to request to allow disclosure of the return or return information to a third party, advocate your position to another third party or to the IRS, execute waivers, consents, closing agreements, or represent you in any other manner before the IRS. This document is only for getting information from the IRS. That's it. But it's a great document because anyone in my office, whether they have a license or not, can use this to get information. It's a fantastic resource for that. It allows us to download transcript data. And then if we discover in that process that there's a serious problem, like, for example, maybe they're being investigated by CI, criminal investigations, or we see, or they're potentially being investigated by CI, or they've been represented by 20 other firms. Well, that tells us something. They're not willing to make changes, or they're a tax protester. some other fact that we just didn't plan on. We want to know that before we actually engage in a representation agreement. Now we're obligated by their, as in our nature, fiduciary nature of being a power of attorney, to actually represent them, and only to let them down. I'd rather, turn somebody down than to let them down. And the best way to do that is from the TIA. So I'm just going to cover a couple of things on the 8821 that I think are important for you to remember, things that we do. Obviously, we always put the taxpayer name and address and their EIN or social security number. The one thing I don't ever fill out is the daytime telephone number, or I'll put our phone number at the office as the daytime telephone number. I don't want somebody going around me, or, and by the way, statutorily, if I'm a power of attorney, they can't go around me, but they can in a TIA. And I just don't want to make it easy on the IRS to contact my client except through me. And that's really important, because I want to ensure that I'm in between my client and the IRS, and they're getting the best representation they can. Somebody that can talk the accounting and tax law that's needed so that the client doesn't get themselves into trouble. There's a lot of times when a client's telling me what they think the problem is or what's happened, they're using their language, but I know that language isn't correct from a legal perspective, and it actually might get them in trouble. So that's why I want to be in the middle. Then under designees, obviously that is us. So whether we're a licensed professional or an unlicensed administrative person in a firm, we need to put that down. Now, here's the trick. Under CAF number, this is an interesting feature. You can actually have a CAF number for an individual or for a firm. We're actually a firm that has a firm CAF number, and then we have a bunch of individuals in the firm who actually have individual CAF numbers. Now, if it's my name, I'm going to put my CAF number. I won't tell you what that is, but anyways, if you don't have a CAF number, don't worry. Just leave it blank. And what'll happen is in about 2 weeks' time, they're going to send you a letter. I don't even remember how many years ago they sent me a letter and said, here's your CAF number. Be sure to keep that, because that's important. Then we have the preparer tax ID number, the PTIN. That PTIN is also important because you should get it if you're preparing tax returns. And that's done on the IRS site. There's a place where you go and you register every year. You have to re-enroll and re-up your year and renew that PTIN. And there's some required disclosures, like I have to attest under penalties of perjury that I don't have any serious tax problems, that my taxes are current, that I filed all my tax returns, that I'm not guilty of any felonies or anything like that. So, you have to certify those things every year when you renew your PTIN. So if you don't have a PTIN, go ahead and apply for one. If you do, then just remember we renew them every December, roughly. Telephone number and fax number, I always put those in. There's only been once, I think I think there's a few more times I've changed address. So once you start changing address, for a little while, I just click that change of address. It's always funny though, because I'm a power of attorney, or I have a tax information authorization for literally probably hundreds and hundreds of people. And you want to terminate them after a while, but every once in a while, I'll get something that was addressed to a very old address. And I just have to laugh, because that tells me that a revenue officer or a revenue agent working for the IRS or some employee didn't use the CAF system and realize we haven't used that address in 7 years or 5 years or whatever. You'll want to list every single person that's authorized to talk on this 8821. And then that allows them to just call in, get the transcripts, get the information, whatever they need. I'll talk more about tax information, because the same conversation will relate to a power of attorney in a moment. If there is a specific use not recorded on the central authorization file, you'll want to check that box. That's line 4. I can't imagine there's anything the IRS would let you do that's not recorded in CAF. So I don't even know why that box is there on 8821. Maybe somebody does. So DM me if you do, because I'd really like to know if there's anything that somebody that's not licensed or filling out an 8821 could do that's not already pre-envisioned by IRS. Next box is kind of important because if there are prior 8821s out there, you need to check this box and include the copy of the 8821 when you submit the new one if you want it to remain valid. So if you're adding staff or say an attorney or somebody else that you want to have information authorization for, just make sure you include the former 8821 and check that box to retain those information authorizations. Because if you don't, they're going to revoke them all. And now you've got somebody that had access that can no longer have access, and you got to have your client sign a whole new 8821. Most important thing here, guys, is make sure that each of your clients sign and date this, because it's not a completed form and CAF will reject it if they don't date it. It happens all the time. So just make sure they're doing that. So we only use 8821 really to get information. If we then want to get into representation for like an audit or a collections matter or advocating with the IRS, now we're going to need to move into the power of attorney realm. And this is where life gets interesting, guys. We have, like I said, hundreds of POAs. So let me just go through. So taxpayer information, same as the 8821. I don't usually put in the daytime telephone number. You do have to put in their EIN or their social security number. I always think it's helpful if you can maybe get a copy of a prior return if you haven't ever represented them before, and just make sure the social security number is correct, or get some other evidence of their social security number, because every once in a while we have one get kicked back because we have the wrong taxpayer ID number. By the way, there is also in this taxpayer identification number, both for the 8821 and the 2848, there is something we call an ITIN. I think it stands for International Taxpayer ID Number. This is a taxpayer ID number that's assigned to somebody who is not authorized to work in the United States. So say an undocumented alien who came here illegally, is working, they don't have a social security number. And so what they do, and you know, there's no judgment here, guys. It's just what happens. They'll use a fake social security number. Then the IRS creates a means for them to file tax returns by issuing them an ITIN number. They can't use the ITIN number to work, but the ITIN will assign a taxpayer ID number to this individual, and that will allow us to then represent them. You don't want to put in the fake social security number. You want to get an ITIN assigned out, and there's a whole process for that. There are even firms that specialize in getting ITINs. We don't do it anymore. I have done it in years past, but for an undocumented alien, they are going to need an ITIN number there. Representatives, that's the same as before. If you don't have a CAF number, send it in blank. They'll assign one to you. PTIN, you've got to go to the IRS website and register and re-enroll in the PTIN program every year. And then, you know, here it shows you can have 4 representatives. There's a check box that says check if to be sent copies of notices and communications. That's a really important box to check for at least one person. Now, in our office, we'll list more than one representative, more than one person that's authorized to talk to the IRS. And where they work in my office, we don't check more than one box. We only check it, say, for me, because I'm not going anywhere. Whereas one of my staff, maybe in 5-10 years, hopefully never, but maybe they leave our firm, they go to another firm. I don't want communications to continue to come to the departing staff members. So for us, I always put it as me, and we check the box to be sent copies of notices and communications. Guys, this is a really important box to check. Here's why. Every notice your client gets is going to be carbon copied to you in a separate piece of mail. And a lot of times when my client calls in a panic because they got a notice of levy or notice of intent to levy, say a CP 504, they'll call me and we just got it that day. It's been scanned in and I already know about it. And sometimes it's already on somebody's call list to call them and just let them know, hey, it's a CP 504. You are in the audit cycle or you're in the collection cycle. We have to wait for an LT11 or a notice of levy. It comes with appeal rights. It comes in a certified letter. We're okay for now. But we like to see these notices because it tells us where people are in the collections or the audit cycle and what's happening. Worst thing that can happen is your client gets a notice of deficiency, a 90-day letter from the IRS, and they've got 90 days to petition through the tax court that they don't agree with the proposed adjustments. You miss that 90-day deadline, there is something you can do. You can ask for an audit reconsideration, but you better have some new facts. You better have something different. It's just a little bit more nerve-wracking to not have tax court privileges. The reality is, if you get the 90-day NOD, you've got to file a tax court petition, but they'll probably kick it over to appeals. But at least you've got the assessment still in play to where you can get the assessment removed. I did have a client recently. During COVID, we probably filed 3 or 4 tax court petitions. And because mail was so backed up in the tax court and at the IRS, they didn't process the mail, even though the petition was delivered on time. And what happened is our clients got assessed. Then they started going the collection cycle, notice of levy, notice of intent to levy, all these things. And we just called the IRS and asked them to extend the deadline because it hadn't been recognized by the tax court yet. Well, recently the tax court started to catch up on their mail. So some of these that got assessed, they've actually revoked and removed the assessments now pending the tax court's decision. And in all cases, almost all of them are over in appeals anyways. So most of our tax court petitions never see the light of day in a tax court for a couple of reasons. One, they usually want it to go over to appeals, see if we can resolve it there. Number 2, once it goes to the U.S. attorney, we're really doing things to kind of, bring understanding to whatever the auditor didn't understand or the IRS ignored, and either negotiating or resolving this thing before it ever goes to tax court. Because most of the time, guys, it is not in the interest of the United States tax court to try every case for a whole bunch of reasons. Bad facts, bad, say, auditor or IRS staff that have made the decision, law that would actually go against the IRS. And so the hazards of litigation for the IRS are time, money, and the threat of loss and a really solid court case. About 6-7 years ago, we had a situation where we petitioned the tax court on a case, and I wrote the whole brief for why we would prevail in the tax court. The attorneys came to the table and said, there's no way we're going to negotiate. And I said, did you read the brief? Well, no. Well, I would encourage you to read the brief because you've cited all these court cases and so have I. But the reason I've cited them is because those court cases went one direction and said, if it had been this way, then the case would have held this way. Our case is this way. It's B. And that means we're going to have a successful outcome here. Well, the IRS risked losing that case and then having a case on precedent that would have helped all the other people in tax court. So sometimes it makes sense for the IRS to say, you know what, aside from the costs and the time of litigating this case, we also don't want a really good case on the records that goes against the IRS. That doesn't help us. So negotiation is kind of the name of the game once you hit the appeals and the tax court level. And I would argue, once you get to that level, that's what you're dealing with. So I always, just bringing full circle, I always check this box, checks to be sent, copies of the notices and communication, because you don't know when your client gets an NOD, when they get a notice of levy, when they get appeal rights. All of these things are vitally important. And so you want to at least have the copy. I also tell my clients, send me all copies of the notices you've received already, because if you'll notice when you check this box, it doesn't tell you that they got a notice of levy 3 weeks ago. I actually had that happen to a client. While I was waiting for the POA to clear CAF, I asked my client, what notices have you received, this, that, and the other? And I didn't notice that I didn't know that there was a notice of levy that had been issued over a year before. Now, technically, they should issue a new notice, but they don't have to. And in this case, what happened was between the time we got approved through CAF and the time my client had hired us, they actually got levied. So I was pretty hot. I called the IRS and they said, no, we actually sent that notice of levy a year ago. Well, the client's dead at that point in time. The only thing I can do is claim hardship to get that levy released, beg the RO, And I don't know about you guys, but the ROs to me aren't always very kind, partly because we're in an adversarial relationship and they're dealing with a taxpayer that does not and has not responded to a whole series of notices and all of the enhanced collection activity that the IRS has done. So they're looking to be a little punitive on our clients. So I always like to know what has been sent. And just because you check this box doesn't mean you're going to get prior notices. In fact, you won't. So it's your job to call the IRS and say, what notices are outstanding? Do we have a notice of levy? Do we have an NOD in the case of an audit? What do we have on this matter? And I'm going through all of the facts of the case and building my case file so that I know how to represent this client. I need to know things like the collection statutory end date. I need to know whether they have a notice of levy and they have a 30-day deadline to do a collection due process appeal. I need to know if I've got an NOD and a 90-day timeline to file a tax court petition. These are all things I'm building in the case file. All right, let's move on because part 3 I said I'd talk about because it relates also to this TIA, the 8828. And that's important because some of the same tax matters are going to be dealt with over and over again. I just got to find this. 8821. I just had a brain freeze, guys. So not the 8828, 8821. Anyways, now we're on the 2848. And in box 3 is where you are specifically identifying the acts you're authorized for. So I always, on a collections matter, have, and oftentimes the first one I'll have in an audit matter, but the first line is always usually income and then the tax form number. So that could be a 1040, could be an 1120S, could be a 1065, an 1120. And then I put the years through which I'm covering. I always like to go at least a year or two before the problem occurs. So if they say, well, I haven't filed a tax return since 2014, I might put my POA from 2010 or 12. I'll go before when they think the problem is, because I've learned that usually the problem's a little worse than the client describes. So I always like to have a little bit of overage. And then you can go 3 years forward. Right now, the form I'm looking at goes through 2023. This is an actual one without client information on it. But I've requested for this client 2010 through 2023 on the 1040. That seems like a lot. So column 1, income, column 2, 1040. Column 3, 2010 to 2023. We might have employment or payroll in column 1, and in which case we would likely see 940 and 941 in column 2, and then the years covered as well. I don't put the individual quarters. I find that to be a waste of time for a 941 or an employment or payroll matter. I just put a broad category or a broad range of years. So I go at least a year before when they think the problem is, and I'll put it forward a year or two because we're going to be working with the client sometimes for a period of time. And I want to make sure I don't have to go back and ask for a new POA as we run out of years. The next line, I always do something for 1040s for individuals. I do income in the first column. Second column says 1040 dash separate assessment. You might ask why. Well, call it trial and error. I had a client once that went through a bankruptcy and a divorce. And what the IRS did in the bankruptcy is they created a separate assessment account. What that means was they took all of the balance in this normal 1040 assessment and they created a separate assessment. And I'll tell you how this happened because, and I do the same period of years as I do the normal 1040. It's just on a different line. It says separate assessment. Reason I do that, guys, is, and I got lucky because a lot of times when I'm talking to an IRS employee, they'll say there's something else. They'll give me a hint. They'll tell me, John, I got something else on this. I can't tell you what it is. I'll say, well, give me a little coaching here, guys. And a lot of them are really resistant to telling you what you need because then it reveals the hand of the IRS and what's going on. And this person said, I can't tell you what it is, but do this. Put in 1040 dash separate assessment and you'll know why once you get the information. Then once I did that, I found out that there are some unique situations where they'll actually transfer the assessment, the balance, over to a separate assessment account. So when you pull the transcripts, you think you've got all the balances owed, but they've also got a separate assessment account and you don't have all the balances. And that's what happened in this client's case. Is he had some separate assessments. So we thought his balance was lower, but it was actually hundreds of thousands of dollars higher because he had the separate assessments as well. And so just chalk that up to experience, guys. If you're on a 1040, I'd always add separate assessment and then put the years involved. The other thing I've also learned by sad experience is, even though you've got income 1040 and the years involved, what they won't give you is civil penalties. So that's not going to be on your transcripts if you don't ask for it. So I always ask for civil penalty as well. Then I put NA under form number, that's column 2, and then I put the years. So there is no tax form number for civil penalty. It's kind of like a misdemeanor, and so that it's a fine associated with a civil infraction with the IRS. And so there is no form, it's just an assessment that happens. And so I always, and I've just learned again by sad experience, you might think you have everything, but then you got a civil assessment, and I need to know all the balances owed in a collections matter, because I've got to deal with all of them in an installment agreement or in an offer in compromise or in a partial payment installment agreement, a PPIA as we call them. I've got to know everything going on. Now, there's some other things you can put in here, like a FOIA, Freedom of Information Act request. Again, the tax form is going to be NA. You got to put the years. Now, a FOIA, it's interesting because sometimes I've had to tell the IRS we're going to hit you with a FOIA because I've got a RO that won't give me information, who thinks that they don't have to publicly disclose things in the file. And it's really important sometimes to get a FOIA, because when you start to see redactions, large redactions, then you know that CI is involved, criminal investigations, and you probably better have a Covell letter with an attorney, because at that point, the only attorney-client privilege you have is if you're hired by the attorney. You don't want, if you think you've got a CI case, a criminal investigations case, you better have an attorney involved. You better be working for the attorney and not the client, because that's the only way you're going to have attorney-client privilege. We've got a great law firm that we work with, and any tax matter we have where we think CI could be involved or it could go to tax court, and we don't want information to have to be disclosed to the IRS, we'll just put a Covell letter in place that says we work for the law firm, they pay us, the client pays the law firm. They set up a separate retainer agreement with the law firm. We bill the law firm bills the client. Now all of our communications and documents are privileged from that point on. And I think that's really important, particularly when you think CI is involved or you're starting to push the edge on, needing FOIA and other things. Whistleblowers, another thing you can do. I haven't personally represented anybody on whistleblowers or practitioner discipline, but I can tell you, I've seen a whole lot of cases in the collections and the audit area where some practitioners ought to be disciplined. And in fact, an audit we just closed out about a month and a half ago, the practitioner had made so many mistakes. The revenue agent kind of tipped his hat and said, yeah, we're going to be looking at this CPA quite a bit more, probably pulling in all his returns for audit. Private letter ruling, a PLR, again, that's not necessarily related to a tax form. You're asking for a specific ruling from the IRS specific to a client. And so you'd want to put a PLR in there as the description of the matter. It's NA again for the tax form number, and then put in the years involved. So I'm going to move on. There's a lot of things that you can be authorized for that are pretty common through CAF, but it's hilarious when I get POAs from other people, because inevitably I see they don't know what they're doing. Again, I would say make sure on an individual matter you always have 1040 separate assessment, and then as a separate description of matter, civil penalty. I see those pretty consistently as just in case. You want to make sure you're grabbing the separate assessment balances and any civil penalty balances. All right, box 4. I personally have not had a need for using this outside of the scope of what central authorization file or CAF unit uses things for. I'm certain there are some matters. I haven't had any, and I've represented a lot of people in a lot of crazy types of matters, but I have never had a need to check that box in a matter that I couldn't disclose under item 3. So most of the stuff I deal with, actually all of it, I've been able to put under box 3. So I don't see a need for using box 4. Maybe now that I've mentioned it, maybe in the next week something will come up where I need to represent a client. It's not it's a specific use and not outside the normal. We see that we see a lot of out of normal, but I've never had a reason to check that box. So let's move on to 5A, additional acts authorized. This is an area I feel very passionate about. There are 3 boxes I always check. One is the first one, access my IRS records via an intermediate service provider. There are 3 intermediate service providers. They're kind of the predominant firms out there for this. I use 2 of the companies a lot. One is Tax Help Software. Roger, the owner there, is a good friend of mine. We talk a lot. Going to try and do a live with him for our tax professional community here in the next couple of weeks, talk about our boot camp, which Malcolm, remind me at the end, I got to talk about the boot camp, okay, coming up. But what this allows you to use is a third-party software company like Tax Help. Pitbull is another. Canopy is another. I use Tax Help software for pulling down transcripts, organizing reports for our clients. I use Pitbull for collecting data for, say, a 433A, which is a collection information statement or financial disclosures, we call it in our office. But I can't imagine doing this business just through e-services. I've been in this business long enough to have done things through e-services, and I think I was one of the very first users of Tax Help software. And when I did in 10 minutes what it would have taken me 2 hours to do, I got to tell you, I flipped. I was so excited by Tax Help software. If you're not using a third-party intermediate service provider, one of these software companies to pull down transcripts, I would highly, highly recommend you look at one of them. My preference is Tax Help software. I use Pitbull, as I said, for a different reason, but you could use Pitbull and Canopy. Those are the big 3 that I know of. There's probably others, but I've been in this business a long time. I actually have used all 3 for different reasons, but my preference for pulling down transcripts is Tax Help. And if you don't have that box checked, you can't use the software. And this box has been added in probably the last 2 years, I think. It used to be we didn't have to check this, but now we do. And it's because one of the providers out there made a massive mistake and didn't do things the way they were supposed to do. They didn't do them right. I won't say who it was, but they didn't do things quite right. Next thing you know, CI's involved, and boy, they had ruffled a lot of feathers over at the IRS. And the way we solved this so that those of us in the profession could easily gain access and manage the data that's coming out of transcripts was to add this box. And I have Roger to thank for that. He was kind of at the forefront of this with Tax Help software, influencing what was being done and ensuring that we still have access to transcripts. The next one I always check is authorized disclosure to third parties. That's going to lead into my 7216 conversation in a moment. And then finally, substitute or add representatives. Let me tell you why we check that box. I'm probably like you. I have multiple professionals, tax professionals working for me. And if somebody leaves, I can remove them without their being involved. And I can add another, say, enrolled agent, CPA, or attorney to the case without my client signing a new power of attorney. What do we got? We're good? Okay. And so I like to check that box because I don't have to go get a new signature from my client. I just add the new tax professional, the new license, their CAF number, PTIN, and everything, and then I can actually sign it on behalf of the client, run it through CAF, and they can get authorized. It's a great way to save yourself a little time in the future. Now, I don't ever personally want to sign a return. So I don't check that box. I suppose if somebody was going out of the country, there might be a weird situation, but I've never felt like it was a good idea to sign a return, because that takes me to a new level and puts me more in the shoes of the taxpayer, obligates me more. And if my client's lying or doing something shady on that tax return, I don't want to place myself in a position of risk. So I don't ever check that box. But in 5A, I always check access my IRS records via an intermediate service provider. That allows me to use Tax Help and Pitbull and Canopy. Authorized disclosure to third parties. That helps me to be able to talk to others within my firm, maybe outside, but I doubt it. And I'll talk about that in a minute, why. And then third, substitute or add representatives. That just creates efficiencies down the road. So turning a page over, the client would actually fill out line 6B if they want to exclude certain things, but I've never filled out 6B. And then, 5B. And then item 6 is retention or revocation of prior power of attorney. Now, if you submit, just like the 8821, if you submit a new 2848 and you don't check this box and attach to it the prior POAs, they're just going to automatically revoke everything out. Now, where that's important is we work with tax attorneys all the time where they've got a case going to tax court or something, and they want to bring us in on it to help work with the U.S. attorneys or the appeals office. We'll fill out the 2848, or they will. Usually we will, but we're going to always want to check that box and leave the attorneys on as POAs. Nobody wants to go to the attorneys and say, I accidentally revoked your POA by filling out a new one. So I always get a copy of the old POA and I check that box if I want to retain somebody. Now, if it's a prior tax professional who didn't know what they were doing on the audit or didn't know what they were doing on the collections matter or neglected some things, I'm going to leave that blank and revoke them out. But if I'm working with another professional, I'm always going to want to make sure I leave them on, or at least have that conversation with the client. Do we want to revoke them out, or do we want to leave them on? If we want to leave anybody on, make sure you check the box and attach the prior POAs. All right, box 7 or line 7. This is where the client needs to sign and date. Remember, they've got to date this. If they don't date it, which every once in a while, as we do so many POAs, every once in a while, it'll come back and the date's missing. And I'll ask, how did this happen? I don't even understand. Sometimes it was just faint. So here's one other thing I always do. I always ask the client to either return the actual physical copy of the POA or do a really clean scan. That doesn't mean they go get their phone and they take a picture or they use the phone scanning app, because guys, it always looks terrible. It always looks terrible when they fax it. Now, if we have to, if it's a necessity, then we will, but I guarantee it, a fax to me and then a fax to the CAF unit inevitably is going to inobviate this 2848, because they're not going to see a date. They're not going to be able to read the client's name. It looks terrible, whatever. So I always like a really clean copy for page 2, so they clearly see the client signed and dated this POA. We've signed and dated it. It has our designation as a CPA, an attorney enrolled agent, where our license is, what the requisite license number is, and our signature and date. Just make sure everything's dated, including you and your client. Because if you don't, they're not going to accept it through CAF. And unfortunately, you're going to find out 10 weeks later, and it's just going to frustrate your client. It'll frustrate you. So do everything you can to make sure this page is correct. And I always, like I said, I always fax it to the CAF unit. And then if I've got to get a hold of the IRS early, then I'm gonna call them and then fax it again. Largely, I'm relying upon administrative staff to complete the power of attorney with my clients, and I'm just responsible for signing at the end and dating, as is my other staff who are listed on the POA. Guys, if you want to do anything with the IRS to represent your clients, you have to be able to do it with a POA. You have to fill out the POA. They're not even going to talk to you. They're going to laugh at you. I do think it's funny, though, every once in a while, before I put a POA in place, I might talk to an RO or a revenue agent, and they'll give me information without even having the active POA. I think it's funny because technically they're violating the law. But I don't call them out on it. Now, there is one other thing I want to talk about real quickly on the POA. Guys, once you're the power of attorney, the IRS, that revenue officer, that revenue agent cannot go around you to your taxpayer, to your client. If they do, it's a violation of statute. It's a violation of their, it's a violation of their taxpayer rights, and it's a statutory violation. Now, here's how I handle that, because it has happened. It hasn't happened often, but every once in a while it happens. And I got a revenue officer with a little bit of attitude, and they tell me, no, I can do that. And I say, actually, you can't. There are provisions for them going around a POA, but it's usually if you're in neglect, gross neglect of your client, you're not responding to notices and you're not doing your job. Well, that hasn't been the case for me. We're very active in communicating with the IRS, but there are a very narrow set of circumstances, and there's a very firmly established policy for going around a POA. And so in all practical reality, it should never happen. So I always call the RO and I say, hey, I got to talk to you about something. So first off, I just want you to know that my client and I assert all of the rights that we have as the power of attorney. And I understand you contacted my client, and I'm going to ask you not to do that again, because it is a statutory violation and it's a violation of taxpayer rights. Now, if I get a guy with attitude, sometimes they'll tell me, I can do that all I want. And I say, listen, you don't want to go there. I give everyone a free pass. And that's what I tell them. Look, I give you a free pass this time. You know, you may have forgotten, which they didn't. You may just not have noticed that I was the active POA, which that would be neglect on their part, because they're supposed to check the CAF system. It just should never happen. But I'm a nice guy. So what I'm going to do is I'll give you a free pass once, but you can't do that anymore. And then if they give me attitude, I say, guys, you don't want to go there. Here's the code section. And usually it puts them in line, and they understand that they cannot do that again. You do not want them going around your client or around you to your client. Bad stuff happens all the time. Furthermore, when I take a new client on, I always tell them, you cannot talk to the IRS at all. You have to go through me, because I don't want them saying something that is in their minds correct, but legally incorrect. And it's a misrepresentation of them. And now it could actually go against them. How are we doing in time? Oh, good. Okay. Let's talk about a 7216 consent. One-page document. Guys, I see this as a huge problem in our industry all the time. If you talk about a client or release tax returns, here's how this happens. Somebody calls us and says, can you send my tax returns over to my loan officer? I'm refinancing my home, or I'm buying a house, okay? I tell them, yeah, I can do that. But most of the time I'll say it might be faster if I just email those or send those to you in an encrypted format and you give them. But if they want me to communicate with anybody outside of them, and that's them personally. So if I'm representing John Jones, and John Jones calls me and wants me to send his tax returns to his banker, and he doesn't want me to send them to him, and then he send them on to his banker, then I've got to have a 7216 consent. And this is the law, guys. And all the time, I'm talking to other practitioners, and I respect the guys that ask me for a 7216 consent. And usually I've already got it, because I know they're going to ask for it. But I got to tell you, 90% of the time, the other attorney, CPA, enrolled agent never asks for the 7216 consent, and they give me all the information I want. It's actually kind of funny. But my staff know that for us to send out any information on any client to anyone other than that client, we have to have a 7216 consent. What I would suggest is that you look at the rules for 7216 consents, because it even tells you what font size you have to use. It tells you the structure of the form. It's ridiculous, the stupidity that some Congress, men and women went to saying this is what the form's got to look like, because it's overkill. But if you don't follow the policy, you're in breach of the law. And I see this happen all the time. So in terms of exchanging information with people other than the IRS, tax information or confidential tax information, I can't recommend more than you get a 7216 consent for you and your firm so that you give this stuff. So these are just some of the things we're dealing with, guys. Now I want to, first of all, should I address any questions, Malcolm? Nope. Okay. So I want to just mention we've got a partnership boot camp coming. And we want to invite you to that. It's going to be August 17th to the 19th. Go to privatetaxeducation.com. You'll find out everything you need to know about this partnership boot camp. I love doing partnership returns. They represent a great value opportunity for your firm. You know, most of these returns are high fees. They involve lots of partners. And so you not only have the partnership return, you often have partner returns, complicated tax returns, generate really good fees and great clients. We're going to give you what you need to know to help you in your practice really build this competency for providing tax advice and tax compliance work for partnerships and partners in this boot camp. So go look at our website, Private Tax Education, and register for our boot camp. We're offering an early registration provision. I know the guys at Tax Help Software are also going to be promoting this starting next week. But you get the same opportunity, whether it's registering through us or them. You get the early bird registration. Register now while you can and while you're thinking about it, while you're planning your summer. This is going to be 3 days of information-packed material and help you build your business and help build your competency around providing partnership tax returns and returns for partners. I look at it as you'll recover every dollar you invest if you just put it into your business in fees manyfold, if you'll just implement what we're going to teach you. Second, it'll give you the continuing education you need to maintain your license, and that's always good. But my goal is to teach you in a way that it becomes a new business opportunity for you. So August 17th to 19th, go look at the site. I'm going to have some others join us that'll help you understand this area of complicated tax law. I think these are really complicated returns, some of the most complicated out there, but it'll be an incredible practice opportunity for anybody that joins us. I think that's it. It's been almost an hour. Boy, the hour goes by quick, especially when I'm talking about tax representation and resolution. I teach a lot of continuing education, guys. And I obviously spend a lot of time with taxpayers who've gotten into a lot of trouble. And I think I've learned everything by trial and error and making mistakes. So don't make my mistakes. Learn from us. Come to our events. Come to our boot camp in August and figure this stuff out. And it'll only bless your business. So have a great week. We'll be back next Tuesday and give you some new information that'll help you in your tax business. Thanks, guys. Okay.